This case is an Aboriginal land rights case which occurred before the epic decision in Mabo against Queensland. So it doesn't really help us to understand anything about the management of Indigenous land rights, but it remains a crucial case for understanding certain aspects of administrative law. Peko Wallsend was a company mining for uranium in the Kakadu in the Northern Territory. The mine is known as the Ranger Uranium Mine. Around 1980, traditional owners made a land rights claim under the Aboriginal Land Rights Northern Territory Act 1976. Once the claim was made, the Commissioner had to consider the interests of all parties and then make a decision. One of those parties was obviously Peko Wallsend. During this initial process, there seems to have been some confusion about the precise location of a uranium deposit known as Ranger 68. The Commissioner made his decisions recommending that the Minister grant the Aboriginal claims over the areas of land without realising that the areas claimed included Ranger 68. Once the Peko Wallsend company realised that the grant was going to include Ranger 68, they brought this to the attention of the Minister, who failed to take that new information into account. The Minister made the grant. The High Court found that an administrative decision is not properly made if the decision maker ignores or does not consider evidence that they properly ought to consider. Justice Mason said the failure of a decision maker to take into account a relevant consideration in the making of an administrative decision is one instance of an abuse of discretion, entitling a party with sufficient standing to seek judicial review of ultra vires administrative action. The unusual question in this case, though, was whether the decision maker had to consider information which came to light after the initial process of gathering information. In other words, was Peko Wallsend stuck with just the information they had supplied initially, or was it okay that they supplied additional information later? Justice Mason said, "It is but a short and logical step to conclude that a consideration of that factor must be based on the most recent and accurate information that the Minister has at hand." From this case, we learn that if the decision maker has information available, even if that wasn't supplied through the normal process, they have to take that information into account. They cannot ignore relevant evidence.